Mr. Viswanathan, who is the architect of the bankruptcy law code, something that will be taken up in the winter session of Parliament, is here with us to take forward this discussion. Thanks very much, Mr. Viswanathan, for speaking first and exclusively to ET now. My first question to you is, what was your big mandate? What was your aim while you were trying to work out this, the bankruptcy code, so to say?
Our mandate was given by the Finance Minister in the last budget speech to evolve a comprehensive insolvency code for cutting across all the laws, a single comprehensive insolvency code. The law relating to insolvency in Indian statute book was scattered. We had two old acts, the Presidency Towns Insolvency Act and the Provincial Towns Insolvency Act, which were enacted 100 years ago and which were not of much use, where the district courts were the courts where people had to go. As far as corporate insolvency is concerned, it was handled by the high courts and later by the national company law tribunals. And the state of affairs was far from satisfactory because it took a long time for companies to be liquidated, and by the time creditors could realize their assets, there was nothing left in the assets. So we were asked to proceed to evolve a system globally which is consistent with the other countries, which will facilitate easy flow of credit other than banks. So we are basically looking at developing debt market and corporate bond market, and we are also seeing how unsecured creditors could also be given some priority in realization of the debts. So with this mandate, we have evolved a code with the Insolvency and Bankruptcy Code, which deals comprehensively with individual insolvency as well as corporate insolvency. The corporate insolvency part is taken care of by the National Company Law Tribunal, which is already in position. And as far as individual insolvency is concerned, we are trying to empower the debt recovery tribunals in a big way. They will take over this jurisdiction from the district courts, and this will require a massive infusion of funds where we have to have more debt recovery tribunals. But the whole cutting edge of the whole process is the evolving of new professionals, the insolvency resolution professionals, which is a new breed of professionals who will be turnaround specialists. They will be in charge of taking over the management of the companies and running them, and turn around and see whether they will be able to revive it, otherwise to liquidate it and distribute the proceeds. This is what this mandate we have tried to capture in our code, which runs into nearly 240 clauses, and we have offered it for public debate, and we are open to suggestions and also for modifications if necessary. It had been a very difficult task to draft a legislation cutting across various laws because it impinges upon various statutes. We have done within a limited time available, best of ability, we are offering it for public debate.
Mr. Viswanathan, I'll just take a cue from the answer that you gave me. The insolvency resolution professionals, India does not really have people like those readily available right now. Will that be a big challenge area, the fact that there are not enough professionals who know the art of either liquidating or reviving companies? There is not a ready pool that we can tap into?
No, already we have providing for a transitional provision. So we will make use of them till there is a board. We are thinking of constituting a board. The code provides for constitution of an insolvency resolution and bankruptcy board, which deals with regulating these professionals, because these professionals will be playing a very important in matters of resolving insolvency. So they have to be bound by a code of conduct, and they have to be tied to a strict code of discipline, because otherwise there is bound to be lot of misfeasance. So the board takes care of that. We are also providing for information utilities, which is availability of information about the debtors, their credit worthiness. Right now this information is scattered and it's not readily available for those who want to lend money. So this will be readily available in a database so that creditors can make a wise decision, and it will be easy to resolve insolvency related matters where people cannot cheat, hide or siphon off money. These things will become difficult.
Mr. Viswanathan, your law panel proposes a 180-day limit to deal with insolvency. A lot of people believe this is going to lead to a time crunch of sorts. This is just 6 days from the time it's first reported to the time it's resolved. 180-day, what was the rationale in arriving at that period?
180 days is nearly 6 months, and during these 180 days, even secured creditors cannot enforce the right. So there is a time, sufficient time is available to find out whether an enterprise is viable or not. So you take a decision within 180 days. If you can't revive, there's no point in keeping it alive. So you have to liquidate it. So there is no point in prolonging this period. We are even providing for a fast track arbitration, 90 days. So 180 days is sufficiently long enough to find out whether an enterprise can be revived or it cannot, so that it should be liquidated. So a decision can be had even before that. We thought 180 is a reasonable time.
I also want to talk to you about the fact that the insolvency resolution plan prepared by the resolution professional has to be approved by a majority of 75% of voting share of the creditors. Is that the global norm, 75%? And how did you arrive at that figure?
This is prevalent in other countries, and then this is, I think it appears to be acceptable. Otherwise, 75% is, I think, the reasonable limit. It can't be less, it can't be more.
There is no mention of willful defaulters. Banks, the RBI, finance minister, they've all spoken about willful defaulters and how banks need to deal with them. What measures does this law really provide as far as willful defaulters is concerned? It's a point well noted that when a company runs into trouble, you've got to have insolvency laws so that they're either revived or they're shut down and the NPO and banks kind of gets reduced. But what about willful defaulters, people who are willingly not paying what they owe to the banks?
No, if you see, these things will be a thing of past, because once you have this code in place, you have enough provisions to deal with that. It's very difficult to evade. See, willful defaulters, the insolvency resolution plan which is prepared, it will take care of everything. The creditors will have the upper hand, so the management will not be in a position to do what they do right now, because the control will be taken over by the insolvency resolution professional. There is a provision for interim professional who takes over, and then the creditors committee decides that. So these willful default and other things will not happen when this regime is fully in place.
Sir, also your panel's recommendations does talk about, I want to especially draw your attention to what happens to cases that are currently under corporate debt restructuring. Is there a mechanism or a provision so that these cases get transferred under the new law? Have you made provisions for that?
No, the existing laws, I think they have to come before this. They have to file a fresh application. But as far as the corporate insolvency is concerned, as far as the individual insolvency is concerned, we have not touched the existing proceedings because it is scattered around the country and we are not sure they will continue.
So the bill proposes for information utilities which would collect, authenticate and disseminate financial information from listed companies. Will you clarify here, is this going to be done for all listed entities? Is this going to be done for listed entities that owe money to the bank and are not, not in a capacity to pay? I just want to clear the air on this one.
No, No, we want to have an information utility covering everything. We want to have a universal database where any person's credit thing can be available immediately, not only to listed companies.
Are you not stepping into the shoes of a SEBI or a banking regulator as you look at doing that with this new law? Because that's exactly what market regulator and RBI is supposed to do.
No, we are only, the information utility only collects information. We are not going beyond that. That information will be used by the insolvency resolution plan. We are not doing anything. We are not impinging upon the functions of SEBI or any other board.
One final question before I let you go, sir. With the introduction of the bankruptcy law, what happens to the existing legal framework that there is in place, the Sarfazi Act, the DRT? What really happens to that? You started this interview by saying there was a maze of regulation, sometimes overlapping each other, and which is why you needed these laws to be in place. But what happens to existing laws that I mentioned?
We are amending. You see the schedule to the Act, the amendments to the various Acts have been indicated there. We are not, the Sarfazi Act is only, there is a minor amendment, we are leaving it intact. There is an amendment to the recovery of debts due to banks and financial institutions Act, where because now it's not merely a recovery of debt, it is something more, it's a bankruptcy court also. So the title changes, and then the Debt Recovery Tribunal takes over the functions in addition to the existing function of recovery of debts, also to deal with individual insolvency matters, individuals and in partnerships. And the amendments to the Companies Act which are required have been indicated in the schedule. And the Presidency Towns Insolvency Act and the Provincial Towns Insolvency Acts both are repealed. And there is a minor amendment to Partnership Act. So these are very clearly laid out in the schedule to the code which we have offered for public debate. And we stand corrected if any other law has to be amended, we will look into that.
Fair point indeed. In the list of ease of doing business for India, the World Bank had very categorically mentioned that there needs to be an insolvency law or bankruptcy code in place for India. Now that you have one, and we will hopefully see the light of day come the winter session of Parliament, how many notches will this really take up India's own ranking in the World Bank ease of doing business list? We are at 130 right now.
No, see, World Bank ease of doing business is only one part of the thing. Even otherwise, this reform is long overdue, and this is necessary for our one of the part of the legal reforms. So, World Bank report is only part of it. Our larger idea is to have insolvency code for a single code for the entire country, which we have attempted.
Mr. Viswanathan, the architect of that panel, something that will bring into court a bankruptcy law for India, long demanded by both foreign and domestic investors, and something that is perhaps going to ease the burden on the balance sheet of banks. Thanks very much, Mr. Viswanathan, for talking first and exclusive right here on ET Now.
Find us on Facebook at facebook.com/ETNow, and don't forget to click the like button. You can also follow us on Twitter at ETNowLive. To stay updated with all our programming, hit the subscribe button on our YouTube channel by logging on to youtube.com/user/ETNow.